Hello, my name is Zuzanna and I'm an associate solicitor in our family team in Huddersfield at Ridley and Hall Solicitors.
Hi, my name's Corinne Barnett and I am a solicitor at our family team in Huddersfield.
Today we'll talk to you about orders available for parents who find themselves at dispute about child arrangements.
So there are a number of orders available for parents that find themselves in this situation. So they're called Section 8 orders. Now, there is a Section 8 order that is the child arrangement lives with order, and that order states that a child should live with one parent or the other parent, or it can be made in favour of both parents. Now, an interesting fact about the child arrangement lives with order is that the order states that you can then remove the child from the jurisdiction for a period of less than 1 month without the other parent's consent. However, you cannot change the child's surname without the consent of all parents with parental responsibility for the child or without a court order. There is also another Section 8 order that is the spends time with child arrangement order. And that's an order that states that a child should spend time with one parent or the other. So this could be on a Tuesday night, for example. Now, an interesting fact about the spend times with child arrangement order is that you cannot remove the child from the jurisdiction for a period of less than 1 month without the other parent's consent. Otherwise, you could be held liable under the criminal offence as a criminal offence under the Child Abduction Act.
Yes, so these are the orders which parents can apply for in order to regulate the children's living arrangements and the children's contact with the other parent. However, there are situations where parents may find themselves at dispute regarding some specific issues relating to their child's upbringing and to their exercise of parental responsibility as parents. These may be in respect of what school the child will attend, what religion the child will be raised within, and the medical treatment, and, for example, the child's specific name or surname, particularly if one parent wants to change the child's surname. Now, in order to ask the court to determine a single issue dispute arising as a result of the dispute between the parents in their exercise of parental responsibility, you should be applying for a specific issue order. A final type of orders available as well are prohibited steps order. Now, these orders are applied to where you want to specifically prevent a parent from exercising their parental responsibility in some way. For example, prevent the parent from changing the child's surname if you know that this parent plans to do so, or preventing the parent from relocating within the UK or taking the child abroad without your permission. These are called prohibited steps order because they prohibit the parent from doing something.
Thank you. So when the court is considering whether or not to make a Section 8 order, the court will be minded to consider the welfare checklist. Now, the welfare checklist includes the ascertainable wishes and feelings of the child concerned, considering the child's age and their understanding, the physical, emotional, and educational needs of the child, the likely effect on the child of any change in their circumstances, the child's age, sex, background, and any characteristics which the court considers are relevant, any harm that the child is at risk of suffering or has already suffered, how capable each of the child's parents are in meeting the child's needs, and also the range of powers available to the court in the proceedings in question.
Yes, thank you. And finally, when these orders were made, when Section 8 orders are made, how long do they actually last for? Now, the short answer is no Section 8 order is made normally that would have effect beyond the child being 16 years old. That's because within the law, the 16-year-old children are considered to be grown up enough to make certain decisions about their lives themselves. For example, if you turn 16, you can apply yourself to change your surname. So in the circumstances, the court will not make an order beyond the child being 16. However, there may be certain situations when the child's needs warrant an order being made for a longer period of time, so beyond that child is 16. And additional caveat on that is that leaves with order, so child arrangements order regulating with whom the child lives, are always made until the child reaches the age of 18, so until they legally become an adult. And finally, the court actually has a power to terminate any Section 8 order at any point, whether on application by either parent or a person with parental responsibility or out of its own motion.
Thank you, Zuza. So those are the types of Section 8 orders that are available to parents. And if you'd like to stay up to date on our Huddersfield Facebook page, as we're going to then later consider CAFCAS's role in the Section 8 order.
Yeah, and one of the other videos that we will do for you is the actual procedure for applying for Section 8 orders, as we think that may help you as well. But if you ever need any help and any further advice regarding applying for Section 8 orders or regarding child arrangements in general, please do get in touch with Zuza or Corinne at Ridley and Hall Solicitors, Huddersfield.
Thank you.
Thank you.